Therefore, there is some burden lies upon the SSOs and the innovators to come out and publicize a reasonable rate of royalty which they believe should be most reasonable. Everything should not be left upon the arbitrator and courts to ascertain and devise, though it is a very complex process, but ultimately courts go through those complex process by the testimony of various witnesses, expert affidavits, and then ultimately they set down the reasonable rate of royalty based on those evidences. Why not this can be done beforehand, at least in those essential patents which are genuinely going in most of the chipset? Therefore, to sum up, what I would say is this: the ascertaining a rate of reasonable, the FRAND terms is a very complex process. If the innovator wants the good incentive, reasonable incentive, if they are really interested in that, they should take the initial burden to come out. Don't leave everything for the implementer to come and negotiate and bargain hard. Their stand should be reasonable, and as Deepak suggested, the innovator is interested in selling those patents, licensing those patents, and not the enforcing through the courts. Probably that where we will see less court cases, more licensing, less infringement, and less intervention by the courts. And then, considering the Indian scenario, the courts then might not be inclined in those cases to issue ex parte or the interim injunction, but to ascertain actually the reasonable rate of royalty, reasonable rate of the royalty as published or as prescribed by the innovator. Thank you very much.
Thank you for that, Sanjeev. And could I ask you, Deepak, do you want to add to that?
It's difficult for me to, digest the issue of publish the royalty rates. When I sit down and negotiate in front of a prospective customer, I'm pretty sure that all of us would have gone to a market and bargained in Sarojini Nagar in Delhi. How many of you would have bargained in Sarojini Nagar in Delhi? Almost 50–60%. Let me, enumerate that in a very common sense. Let him be the, he is the seller. Okay, he is the seller, and let's say that I'm entering into the shop. He will say, 100 rupees, 100 rupees. I will say, no, 10 rupees. Fine. Then what I will do is I will see whether somebody else is standing next to me. Okay. And if somebody else is standing next to me, I will try to ask him, hey, whether you also want it, then I will bargain for you also together. If he sees that, okay, there is a possibility of selling it to two different people, okay, he will say, fine, I will give it to you 10 rupees, at 10 rupees plus, but don't inform to him. It's a very standard operation, I may get a preferential rate because of certain reasons which may be unique to me, but I do not have to always get, he does not have to give the same preferential rate to some, third party. So publicizing the royalty rates, therefore, in my personal opinion, is not so essential. I would say that just go by that there is a FRAND royalty rates which is available. There is a margin between the upper limit and the lower limit. As interested party, if you are asking as to what will be the royalty rate range, I will be more than happy to inform you about the royalty rate range on day one. That's all. And then afterward, let's sit down on the the desk and we will sit down and bargain. In one of the very specific instances which I was dealing with in terms of demerger, there was a huge portfolio of 34 products and a portfolio of close to 1,600 patents in India. The negotiation was happening between the top management, that is CFO level, between the two parties, and they never bothered as to what is the total number of patents involved. They just simply looked at the possibilities of royalty, what will be the break-even time, and things of that nature. CFOs don't understand patents at all. They are only looking at very simple issues. Okay, I have to give him 10 rupees, fine. When will I recover this 10 rupees if I do this? So actually when the bargain is happening between, in that sense, they are not looking at whether there is a patent per se, whether out of the 1,600, which of them is going to be reading onto it, which of them doesn't read onto it. All these are, superfluous. So as a basket bargain is what generally the patentee tends to offer, that, okay, here is a basket of what I believe you might be required to implement it, as either as a standard, as an add-on, or everything. It's not simply a SEP per se. It's a total package deal. Take the package deal, sit down and negotiate on the price of it. It's as simple as that. If you go back into drilling the essentiality of it and things of that nature, you're just simply derailing the entire negotiation by at least, couple of years, or even in a best case scenario, 6 months. Because if I have to look at from a legalistic perspective, what will be the time that I would as a lawyer take to ascertain what is the essentiality of the bigger portfolio of 1,600, I can say easily nothing less than 6 months. So we are just simply negotiating or bargaining it out by more than 6 months. At least some of them will be still essential. You will not say that nothing is non-essential. There will be at least 5 or 10 patents out of the entire basket which will be essential. Assume that you are just simply bargaining for those 10. As a part and parcel of that 10, you are getting the remaining as freebies for you. It's as simple as that. So get the 10 and remaining may be treated as freebies, but negotiate on the price side.
Yeah, I agree that, and as I said at the onset, negotiation is the key to all of this, I believe, but understanding how to negotiate is an important part of this whole process, and knowing, for example, what is the royalty base that you're working around, and that's one of the issues that we have grappled with in the United States.
Sorry, Patrick, could I take a minute in rebuttal? I'll take just a minute.
Well, I was going to...
Okay, you go.
I'll come back to you on an issue. Save your point, though, because I'd like to focus on, look at the inside corporate perspective on this issue and just get a sense, Sheetal, how Ericsson, and I don't know if you're speaking for Ericsson, but I guess we want to say that all these comments are the comments of our panel members and not necessarily those of our firms or companies. But it would be interesting, I think, to hear your perspective. And then, Stefan, I'd like to hear what's happening in Europe on this issue of royalty base and component versus device. But Sheetal?
Well, I won't speak like an Ericsson. I'll just put my hat as a consumer and speak. I think when we have seen in India, and I've told you that it is not really, Sanjeev, an issue about, giving out a royalty chart as to how much do I need to say. The real issue is people do not want to pay. There is an unwillingness. Whether you publish your rates or you do not publish your rate, at the end of the day, you are not able to see unwilling licensees come even across the negotiation table and ask and get a mutual consensus done. So that's the real issue. We need to hit that unwillingness part first and then decide on to what should be the royalty rate, where I should publish it on STO website or not, is it a commercial discussion or not. So anyway, that's one thing. And secondly, I think your concern I very well appreciate if I really put my foot into the shoes of an implementer who doesn't know how much I'll be asked for. I think Delhi High Court has done a very good job already. They have given out an interim order saying that for a 4G compliant phone, you have to pay $1 per, the overall ASP of a phone. And otherwise, it is 0.8%. So I think the rate is not an issue anymore after the interim orders have come out. It's only the unwillingness. Those who don't want to pay will not pay. Don't we see in our media entertainment industry, after 3 months, movie comes out free on TV, but we don't want to wait and we still pirate and we still download a movie. I think it's an inherent genetic makeup. We first need to change the mindset that if I'm using somebody's IP, let's at least go ahead and seek and proactively ask a license. That's one. Now coming back to what Patrick you actually mentioned, and you wanted us to address a question of a chip versus a phone and what should be the royalty base. For the audience, just to bring in a clarity, the debate in India is whether you can, as a patentee, ask for a royalty on a handset. So if it is being sold at a ASP of $150, should you be asking a royalty on this whole handset? Or should it be on a chip, which is a silicon that goes into the phone, which is only a home for the technology to rest? I will like to use a normal analogy of a pharmaceutical drug. Let's say there is a capsule, it has a pharmaceutical compound. So far that compound is in a capsule. Can you ever know what therapeutic value is it producing? So far the capsule, it remains a capsule on a table. Would you ever know what it is going to treat you as? Unless it goes into a body, attaches to a receptor and produce an effect. The issue that Patrick asked is exactly same. Here capsule is a chip. Compound inside that capsule, which is an active ingredient, is the technology. And the body of a human body, this body, is a mobile phone. Unless this chip goes inside into a phone, you can never know what is the value that the technology brings to all of us. And this is the only reason when you go in the market and you purchase a 2G basic phone and you get a 4G compliant phone, what do you pay for more? A 4G compliant phone or a basic phone? You pay more for a basic phone or a 4G compliant phone? A smartphone we pay for more, because the contribution of a technology you are able to see on a smartphone. Whether you can use your internet browsing, whether you can, even if this has 36 GB memory, and the other phone also has 36 GB memory, but one has a 2G, one has a 4G, you will definitely be ready to pay out more for a 4G phone, because now you can click your photos, put it in a storage, put it on an Instagram, use more internet quite often. So I think we should leave away the debate of whether a chip or a handset. We should only, I'm telling you, it's a wild goose chase. Implementer would always want a chipset because chip can be manufactured only in $2, so he'll say, okay, I'll give you some X amount on that $2 and not on a $150 phone. The only point is when you arrive at that FRAND figure, that amount what should be going to the patentee should only be decided basis the value or the contribution that technology is making. And that's the only thing. Whether you multiply a higher number with a smaller royalty base, meaning a chip, or you multiply a lesser number with a higher royalty base, finally you must arrive at a number that is directly proportional to the value that your technology is bringing. And that's the only thing that patentees are asking for. That's from my side.
Thanks, Sheila. And Stefan, could I ask you for some perspective on royalty-based, royalty rate issues?
Yeah,
from Europe.
Let's summarize what I'm in the position that I'm not corporate, I'm an attorney. And I look at it more or less from the infringement or enforcement side. And the general message is, as was already said, royalty rate, ultimately what you base it on, or whatever. It's a matter of negotiation, it's a matter of economics, and I strongly believe that in a good economy with balanced forces and partners negotiating at equal level, you will somehow end up with something that's truly reasonable. And of course, one of the reasons for the debate currently is that we are still in the economic process of finding a level of royalty somehow that is acceptable to all parties and on an economical scale is reasonable. And we have some new players now. Automotive industry is coming in suddenly. This opens new dynamics. I think this is simply an open process that ultimately will result in some practice that is widely accepted. So but looking at from the attorney side, first the case law is very clear, and that addresses what Sheetal said. If there is an unwilling licensee that does not really truly come to the table, tracks out negotiations, that's clear. The full force of the law should come upon this person. There should be an injunction. That's fairly clearly established. But what are you going to do with cases that happen? You have, let's say, Microsoft versus Motorola, Samsung versus Apple, neither of which are professional people who know what licensing is about, and I would guess that the receiving side in these disputes was not exactly unwilling. Still, there is a dispute on the level of the royalties, and the development of the case law and the discussions we had is that the German courts at least have learned, whereas at the beginning they said we should be able to pinpoint and fix a number. They meanwhile threw up their hands and said we cannot